topic is deposits. And this topic is generally, I will say, confusing. Many has many queries. So far, people says, my company is not accepting deposits. Majority companies are not accepting deposits of compliance and reasons whatsoever. But we have to keep in mind there are certain acceptance of fund which can be termed as deposits, this to be taken care, and what all are the compliances. Today with us we have, of course, our own Mr. Bala, a stalwart, and another stalwart in deposits, I'll say specifically, Gaurav Pingle. He is very passionate about this topic. Not only that, I will say entire Companies Act, and he is a regular writer, speaker, and has written books. So, Gaurav, welcome to our webinar. Thanks a lot for your time. And to give a short introduction about Gaurav, I'll say his profile is so long. I asked Gaurav, what to read? He said, just say student of Companies Act. But I set aside, it's his humbleness. He is an associate member of ICICI with 13 plus years of practice experience and industry experience. He has advised, I will say he has given a long list, I'll say from section 1 to last section, all he has advised. He has authored a book on Companies Amendment Act 2017, related party transaction, virtual meeting under Companies Act, security law, which was well received by the readers. He is a very good researcher and religiously authored articles and dedicated column on the current case laws, latest happening in corporate laws, and articulates his views, which are published in leading professional and business journal. Many of it is backed as best article. He is associated with Dr. K.R. Chandrate, past president ICICI, and has contributed in reviewing, editing, and proposing some content of Dr. Chandrate's recent publications, which includes Guide to Company Directors, Secretarial Audit, Compliance Manual, Meeting Law and Practice and Procedure, Company Secretarial Practice Manual, all about private companies, law related to insider trading. Friends, can you believe we have Bible with us? He authors dedicated columns and articles on corporate secretarial practice, conduct internal training program, workshop. He is a regular speaker, and he is also associated visiting faculty for ILS Law College, Pune for 4 years now. He was visiting faculty at various colleges in Bangalore, Mangalore, Udupi. He has to invited to participate in conference, workshop by ICICI, ICI, Management College, Law College. So here, my friends, Gaurav Pingle with us, our own colleague. Welcome, Gaurav. And I'll request Mr. Bala to say a few words on the topic, and Gaurav, your view on the topic of deposit. And then Neel, you can start your presentation. Over to Mr. Bala.
Good morning to all of you. I being an old timer, all this deposit and other thing and all much all came in the new act. Earlier, people used to accept the deposit in the companies. I always remember one of the things in all the companies, as soon as the annual general meeting is over, the very next thing is, accepting of the deposits and the release of the advertisement and filing the necessary things with the ROC, and then going ahead. And there was a requirement with the RBI to file the regular return on the deposits. That was the case. But subsequently, regulators wanted to get into the details of protecting the deposit holders, because deposit being a unsecured sort of a loan taken by the companies for raising the alternative source of the funds. The Companies Act 2013 has brought into this concept. Later on, there are a lot of amendment, etc. You might have seen DBT 1, DBT 2, DBT 3, DBT 4. DBT 3 is the one which is now regularly become a compliance issues. The crux of the matter, as Dipti was telling, is what is actually considered to be deposit and what is not considered to be deposit. And again, what is the exempted deposit? These are all the nitty-gritties which are actually there. Because at the end of the day, as a company secretary, as a professional, we need to advise the right thing to the companies wherever we are, whether it is the capacity of the employment or in the capacity of the practicing professional. we need to do the right thing, right interpretation of the law. So here we have our well practicing friend Gaurav Pingle, which I know him for a long years. He is also from Pune. In fact, when the Companies Act has come for the first time with this concept, he was the first one to write an article on the new concept. What is actually not deposit? What is the exempted deposit? What is the nitty-gritties, etc. Very detailed article has appeared at that particular time till I remember. Then the DBT form was introduced. I had the opportunity of attending his seminar, which was well attended by the what you call economical zone IT park of Pune, and we had a good gathering and a lot of nitty-gritties were actually scheduled to discuss at that particular time. A lot of clarification were also waiting from the government side also. And with this practical experience, I think we will get to clarify, we'll get confirm our views, we can better structure ourselves, how to go about it, getting the things clarified, etc. That's what I think. This is going to be a learning exercise for everybody, even including for me. I would request Gaurav Pingle to add a few words on this topic, and then we can start the presentation. Over to Gaurav Pingle.
Thank you, Dipti ma'am, for the introduction as well as the invitation for today's webinar. Thank you, Bala sir, for your kind words and giving background of today's session. And thank you all for attending on a Saturday morning, around 80 participants today. So this topic, deposits, as rightly said by Bala sir, it was introduced in Companies Act 1956 in the year 1960, when in the year 1960, 1970, when there was a lot of deposits that were taken and not repaid, and companies, what we know it as fly-by-night promoters was the concept that time and probably even now. And therefore we had the strict deposit regulation and criminal provisions for in case of non-repayment. So since 1975, when the rules were introduced, this deposit has been a very important topic. Now it has become an important topic because we have to report under the DPT3 regulations. So the DPT3 form. So I feel this is a very important topic, and every year, there is either kind of a transaction that takes place in a company, or whether it amounts to deposit, not deposit, a loan. There is a thin line difference between a deposit and a loan, and also deposit and exempted deposit, more thinner line than the thin line between the deposit and loan. So it becomes very critical at that point of time, and typically June is the time when we all actually kind of wake up for that kind of compliance, obviously, because we are occupied with other compliance and advisory as well. But anyways, I feel this topic we'll be discussing, though we have deposits, we will focus on the 1820 transactions also, because I feel there are many things, like for example, any amount received by a company from another company. This has a lot of repercussions on other transactions. We have got loans from directors, loans from shareholders, relatives of director. How do you report? What precaution do we take? So we will be discussing that. So with this very short background and introduction, we can start with today's presentation as well.
Neel, you can start, and Gaurav, anytime you want to interrupt and add your point, that only we want from our panelists. All your experience that participant expect from you. So anytime you can interrupt the Neel and talk. Okay.
We are looking definitely your practical experiences and case laws, example, etc. Other thing and all. At any point of time, as soon as the slide goes on, and even for the queries which arise.
And all the participants, you can put your questions in the chat box, and we will take as the topic is going on. We will take it parallelly. Thanks. Neel, you can start the presentation, please. Thank you.
Is my screen visible to everybody?
Yes.
Yes.
Great. So first of all, I would like to thank you, Dipti ma'am and Professor Bala sir, for providing me this opportunity to present myself regarding the topic called deposits. Further, I would like to thank you, Gaurav sir, for being here today, in order to share his practical, experience and knowledge he has in the vast field of corporate law. So, as a general rule, the topic deposit, if you see, so it is not that the person which is from the law background is aware. a common man, if I can say, or a general public also is aware about the nomenclature deposits. Deposits is a terminology used generally in banking sector or in the field of finance. However, deposit under the corporate law is something different, which we will discuss in detail. So if you just focus on the picture on this slide, piggy bank is there. So it is reflecting that it is the hard-earned money of the individual investor that they are putting in the form of deposit or fixed deposits in order to get some return in the form of yield, or we can say interest. So that's why this is a very crucial part that this sector should be regulated very strictly, so that because the public interest is involved, so if the company collapsed or goes into winding up, so the public not faced due to the because of the corporates. So before jumping into the sections, it is very crucial to understand what is deposit under the Companies Act 2013. So deposit is defined under section 2 clause 31. It states that deposit includes any receipt of money, above deposit or loan or in any other form by company, except certain transactions which are prescribed with the consideration of RBI, which will not be considered as deposits. If you focus on the word includes, it starts with the word includes. That means it is a very inclusive definition. It is not an exhaustive definition. In the earlier scenario, in the 1956 Act, if I remember correctly, the definition was something like that: deposit means. So it is a very close-ended definition. But in 2013 Act, it has been changed by the legislature. It starts with the word includes. That means it's a very open-ended definition. There are mainly three ingredients. It says any receipt of money which will be considered as deposit, provided it is a buy of deposit. First ingredient is deposit. Second is any receipt of money by loan, or third is in any other form. Here, actually there are three ingredients, but actually we should focus on only on the two ingredients, that is by deposit or loan. The third ingredient in any other form. If we apply the general rule of interpretation, the rule of ad decem generis, which says that if any general word is followed by specific word or specific meaning, then the meaning of the general word should be restricted to the word preceding the specific word. So we should not elaborate or very widely use the term any other form. It should be restricted to the specific word, that is by deposit or loan. So let's understand what is not deposit. So Rule 2.1c of the Companies Acceptance of Deposit Rules 2014 defines some categories list which will not be considered as deposit, which will not be governed by the Act. So first is the any amount received from the central government, state government, any local authority, or any statutory authority. So if any company is receiving any amount, say for subsidy or in the form of grant from any government, central, state, or local, or say for ICAI or ICSI, which is a statutory authority under Act of Parliament, so it will not consider as a deposit by the company. Further, the rules also state that if any amount is received from any person, any source, which is guaranteed by the central state government, then also it will be exempted from the definition of deposit. So it is very clear, because there is a government, so there is a trust that the money is secure. The government is always standing there, so it will not be considered as deposit. Second is any amount received from outside India. It may be from foreign governments, foreign citizens, or any foreign person, which will not be considered deposit, because here we have to follow FEMA. There is a mother of law, FEMA, which is more stricter. It is governed by RBI also. That's why in order to avoid the conflict of interest, it is not included in the Companies Act. So any amount received from any party or outside India, from NRI also, or from foreign citizen, if subject to your complying with FEMA provision, it will not fall under the definition of deposit. third is any loan or facility.
Sorry, just one point here. We have foreign exchange deposit rules, which is issued by RBI. So we have to ensure compliance of that. So we have to ensure from which account they give NRE or NRO, and that will determine whether it is a deposit under the deposit as in deposit, valid deposit under FEMA and exempted deposit under Companies Act. Then it would be complete compliance of both the provisions. Yeah.
Correct. So I think NRE account is such an account that it will not be considered as a foreign exchange. It is considered as an Indian rupee only. That's why it is exempted by RBI. Third category is any loan or any facility, any overdraft facility, credit card facility, any financial assistance you are receiving from banking sector, banking company, SBI, any public finance institution, regional finance institution, or any insurance company also, it will not be fall under the ambit of deposit. Because there are also strict regulation in the Banking Regulation Act. The watchdog is, RBI is watching carefully. That's why in order to conflict the two regulatory environment, the government has exempted such kind of loan facility from the ambit of deposits.
Yeah, so there is this, I think so, which Neel is referring to is clause number 3 and 4 of the Rule 21C.
Yes.
So this is very important, which he has mentioned, because in the recent times there are many small banks that have come up, and then they are lending to companies or individuals at at a very competitive rate. So we need to check the status of these small banks under the RBI. For example, this example is not of a small bank, but we have got say Skoda Finance or Mercedes Finance and these kind of entities, and these entities give loan to the companies or any person, maybe a car loan or a housing loan. Now, if it is bought by a company, then the question is that whether that falls under clause 3 or 4. So we have to check the status of that entity under the RBI provisions, under what regulation RBI has given the certificate. So whether it is NBFC or a public financial institution or a regional financial institution, and then you can determine. Or there is one more issue which I have actually come across, is typically in say tier 2, tier 3 city, loans are obtained from Pata Samstha. Typically they are called Pata Samstha, which are credit cooperative societies or credit cooperative banks. So the question would be whether it falls under the clause 3 and clause 4 of the Rule 21C. So this is very critical, but in my view, based on my study on the Companies Act and the other banking regulation, that is an exempted deposit, because that falls under one of the entities mentioned under rules, clause 3 and 4 in the rules. So yeah.
So Gaurav, as per your view, there is a loan taken from Pata Sanstha and small bank is exempted deposit under Companies Act, right?
Yeah.
Because it is regulated by the RBI.
Yeah. Okay. Thanks.
If it is regulated by the RBI, then in the Companies Act it is exempted actually. That is the question he is actually saying very clearly.
Yeah. But the only thing is, these kind of financial institutions are not mentioned in the clause. Like we have got very broadly, like PFI, RFI. So
this is, I think, sir, where the role of CS come into picture, in which clause is to fall.
Yeah.
So next, moving, any proceeds by issue of commercial papers or any other instrument that is governed by the guidelines of RBI. So commercial paper is generally used by the corporate sector to for the short-term need, for their working capital need. So this is as regulated by RBI, so it will not come under here. Then the fifth one is a company. Any amount received by a company from any other company. The typical it is called the ICD, intercorporate deposits. So if a company is receiving any amount from any other company, it may be its holding company also, then also it will not be included in the term deposit. Although holding company is a member, but it is fitting in this category, it will not come under deposits. Here a question may arise because the legislature has used the word company and not body corporate. So if I am receiving ABC Limited is receiving any amount of loan from LLP or any financial assistance. So being a LLP is not a company, is a body corporate. So it will not fall under this exempted clause. So this should be taken into account.
Yeah, so just to add something to what Neel has said is rightly that he has mentioned about company and body corporate. So basically money giving entity and money receiving entity should be a company. So other than that, we as compliance officers and company secretaries have to also ensure that it is a deposit, or to ensure that it is not a loan. It is desirable to always enter into an agreement specifying the characteristics that it is a deposit, so that we can take the necessary, you can say, the exemptions or any what is there in rule 21C, which falls under the exemption clause. So in any case, whether even if it is a loan, it is always desirable to have an agreement, which generally in small companies or closely held companies that is not the case, but we have to suggest for having a agreement to that effect. And other than that, like just in a situation where agreement has not been entered into, it is desirable that both entities have a resolution to that effect, that the terms and conditions of the agreement. Because what I feel is the only thing that will distinguish between a loan and a deposit is an agreement to that effect on what terms and conditions we have agreed to borrow, or we have agreed to take the amount. So therefore, this is a very critical aspect. In fact, I also know quite a few incidences because of this clause, which says by one company to another, any amount received by a company from any other company. There are many other transactions which may also fall under this. Like though Neel has not discussed, like for example, debentures. Like we have got convertible debentures or secured, unsecured debentures. Then what will be a situation if one company is giving amount to another company, but it is in the form of a loan or a deposit or a debenture, but it falls under this clause also and that clause also. So this is one point. So maybe we can discuss at that point of time as well.
One query has actually come here.
Yeah.
Private company received ECP from its foreign holding company.
Yeah.
Is it a deposit or exempted deposit? And also the outstanding balance of ECP as on 31st March of previous year, should it be reported in which clause in form DBT3?
Yeah. So there is one point over here in the slide. I think so. It is the amount received from a foreign person or a source. So that is clause number 2 in the rule 21C. So if we have complied with the provisions, then it will fall under the relevant clause.
So I think, sir, it is saying that subject to compliance of FEMA provision. So if we're complying other law, then it is not required to follow both the laws.
Yeah, I think, and also there is a reference of foreign collaborators, foreign bodies corporate,
Bodies.
foreign authorities, foreign citizens. So it will fall under here.
So Gaurav sir is very rightly pointed out that in the precedents also there are various High Court's judgment and Supreme Court judgment that whenever there is a question arise regarding the form or term of loan, whether it is a debenture or deposits. So the court only looks into the intention of the party. What is the intention while at the time of giving the loan? The court looks into the terms and condition. It not emphasizes on the definition in this act. Court, the more focus of court is the substance of the parties regarding the transaction. So it is very crucial and advisable to have a clear drafted agreement before entering into such IC. Next is any companies raising any money by issue of shares or securities, subscription money. Definitely, it is not be considered as deposit, including application money and advance call given. However, company should take care here that the application money which is being received by the company should be allotted, the security should be allotted within 60 days from the date of receipt of money, as per section 39 of that. In case the security are not allotted within the said period of 60 days, then it should be refunded within next 15 days from the 60th day. Otherwise,
It will be a deposit.
yes. The explanation of the provision clearly states that if the company fails to refund the amount within the next 15 days, irrespective companies paying interest or companies bearing penalty under other section, it will be termed as dim deposits.
So that means one non-compliance will actually make you make another complaints.
Yes, sir. Right.
Yeah.
Yes. No, and there is, like rightly said and rightly discussed, but there is one important point. If we see section 42, 62, and all relevant provisions for issue of securities, for section 42 talks about the time limit within which we allot. But this is a very crucial aspect because we have to read section 62 with this rule, which is the clause 7 in the rule 21C, and then we have to consider rights issue. Or so all these issues, in fact, any issue that we come up with is to be read with this. So we have got 60 days only. Now, the question would be, like, money was or offer was made in the month of January. It was closed in the month of, say, January itself. Allotment was not done in the month of February and March. Then the question is whether we report this in the month, and the allotment was done in the month of, say, it was done in the month of, say, April. Okay. Now the question is whether we have to report this as exempted deposits. Now, in my view, this will not be an exempted deposit. In fact, it will be a deposit because we have not allotted within a prescribed time. So you have to calculate. So what is actually exempted deposit is share application money pending allotment. That is only exempted deposit up to 60 days.
Correct.
And that means to give by date means you have made an offer in the month of March and it has not been allotted in the month of March, but you have received the money. So it's neither, it's only share application money pending allotment, neither shares nor refund, and therefore this will be exempted deposit.
Because on 31st March, it is reflecting the balance sheet as a, dim deposit. It should be reported in the form. Debit.
Yeah, right.
True,
and if you allot in the month of April for an offer made in the month of January, it will be deposit, not exempted deposit.
Yes, correct, sir, because the period will lapse.
Yeah.
I have an hypothetical question here.
Yeah.
Now we received the share application money from overseas. Okay, because of the exchange rate, etc., and other thing and all, the money which is received is in excess of the money what is actually subscribed for.
Yeah.
In fact, shares have been allotted, but the excess money lying with the company. But due to some unavoidable reasons, etc., and other thing and all, the excess money could not be refunded. However, the company has made an application to the RBI seeking their permission and explaining the situation. This is the reason why we could not do it, and other thing and all. Beyond this particular date, you give a permission, and we should be exempted for non-remitting this in time, like that. Then in this case, what happened in the intervening period?
Yeah, so I feel this would also be, we can report it as an exempted deposit with a clarification to the form saying that this is the status of the deposit. But just to elaborate on this point, there is a circular of RBI addressed to the AD Bank a long back, which says that if it is an excess of 0.5% or 0.1%, some specific mention which is given. If it is in excess, but and that is a very nominal amount, then they need not refund that amount. But probably in your case, if it is a bigger amount, higher amount, then yeah, then we can mention that in the exempted deposits.
And it has happened during the pandemic situation, etc. Banks were not functioning and other things and all. It did happen with the company. They have actually taken up. The real issue is practically what has happened is, as you rightly say, they have taken it as exempted deposit, and RBI has given the permission. Subsequently, they have remitted the money.
Right.
Okay, go ahead, Dave.
Conservative approach with the regulators to additional compliance. So now moving forward, the next item is any amount received by a company from director or relative of director of a private company. So here there are two categories. If a public company or an unlisted public company, listed public company, irrespective, which is receiving any amount from its director, then it will not be treated as deposit. For private company, there is another layer. The relative, director's relative also, if is giving money, then it also be excluded from the ambit of deposit. But here there are two conditions. First, the person or the director relative, as the case may be, who is giving money to the company shall declare in writing that I have not borrowed money from any other source, or I have not acquired a deposit, and I am again lending to you. So it should not be a rounding of fund like that. And in the votes report also, the company need to disclose that the company has received so and so amount from its director or relative of director. Further, in the financial statement of notes to account also, the same fact should be disclosed. So this is the very, we can say, most attractive tool the corporate sector is using to raising fund for their working capital purpose or short-term fund requirement.
Yeah. So if you see clause number 8, it says, as rightly mentioned by Neel, it says amount received from a person who at the time of receipt of the amount was a director. So of a company. So it can be a private company, public company. So anybody can give in case of for a director or a private or public. But it only thing is one of the condition is that he should be a director at the time of giving the loan or giving the deposit to the loan to the entity, which is one, and only relatives of director is allowed for a private company, not in the case of a public company. Now, the first question would be that suppose it is a private company which is subsidiary of a public company, then what would be the case? In my view, it would be only it would be considered as a public company, and therefore only directors can give loan to that entity. That is one. And second is that borrowing part. Now, borrowing means who is the lender? Is it a bank or a other director or any financial institution, or he has borrowed it from somebody and then giving? No, that is not very clear. So and it is actually sometimes very difficult to even find out that from where he is giving the loan.
I think it is here the word use is not from borrowing. That means it will be a self-generated income, not either source you have taken.
Yeah, correct. But identifying that he is giving it from a source, like just to give an example, that one person is having 3 accounts. He borrows it in one account, transfer it in a saving account, and from saving account he gives the amount to the company. Means what I'm trying to say, professionals, it is difficult to track the source of it. So if possible, we can ask for 1 or 2 questions, but we have to ultimately rely on the declaration of the director. But if we find out that it is from a borrowed source or a borrowed fund, then it will be a deposit and not exempted deposit, because that is the basic condition of exempted deposit, that it should not be from borrowed funds. But what I'm trying to say also is that it is only at the time of receipt of money he should be a director. If he resigns and then still be disclosed obviously as loans to director, loans from directors, then it would be still a exempted deposit.
There is a relevant question has come actually here. The same thing I think somebody has raised here.
Yeah.
Can a private company continue to hold the money received from directors or from their relative even after their cessation? I think that you answered.
Yeah. Okay, I didn't see the question.
Okay, yes. Means, sir, here the crux is that while giving the money, the director, the person should be acting in the capacity of a director at the time of lending money. Once that is the scenario is completed, then irrespective on the date of repayment is director not, it is not relevant.
There is another question which is there actually, amount received as a deposit from the foreign person, will this be reported as deposit in form DPT 3? I think this also we did discuss actually earlier.
Yes, it is not deposit, but in the reporting filing exempted category, we need to mention this. Yeah,
exempted category we need to mention, we need to comply the FEMA compliances on this.
Correct. No, correct. Means what is said is correct, but one important point is who is this foreign person is important.
Yes,
like for example, if he is an outsider, means neither director nor shareholder, then it would be an issue in case of a private company. In case of public company, it would be a public issue or a public deposit.
Yes, so in case of private, it will fall that need to be checked from the status of the person.
Yeah, exactly. And then he has to ensure that FEMA deposit rules compliance is done. Then it would fall under exempted deposit. Yeah. I'll just bring in some more questions, which I generally get it either in a session or for some legal work. So typically there is a question that, sir, the person from whom we are receiving the deposit is also a director and a shareholder. Then what we comply, whether we comply this deposit rules or we comply the 5th June 2015 notification. So in my view, like if we compare both the acceptance of deposit from members and acceptance of deposit from directors. If we see directors, there is no limit on accepting the amount. And if you see the members, we have got 100% limit or some limit we have got. So in fact, we can use this in the favor of company, because ultimately they are only investing and they are only running the company. When you are taking the declaration, you can take it obviously that he is giving declaration in capacity of director. Obviously, in case of members, you don't need a declaration. But if at all it is always desirable also you note it in the minutes, that at least on the accounts approval minutes, which talks about approving the accounts and appointment of auditors, that these are the deposits. And in fact, you can specifically mention that this amount is given in the capacity of a director or in the capacity of members, and necessary document has been done. So this is a very important question, typically which private companies come across.
Very practical questions.
I think
And also a practical solution.
Area, we can say this is a gray area where government has given discretion on the company that you decide in which form or manner you want to receive deposit, either from director or member. So next one is a debentures. So any amount is received or raised by the company by issue of secure debentures or secure bonds. Here, not only we should emphasize on the word secure, but the rule is saying it should be secure by a first charge or a charge rank pari passu with the first charge. That means if the debentures are secure by second charge or subsequent charge, then it will not be treated as a secure debenture as per deposit rules. So this should be keep in mind while issuing secure debenture. It should be a first charge on the assets of company as per the schedule 3, excluding intangible assets. Intangible assets are excluded from the purview of assets under the deposit. This should be keep in mind.
Yeah, even the value of the issue.
Yes, sir. Yes.
Because it says that and listed on, it says provided that if such bonds or debentures are secured by charge, excluding intangible, the amount shall not exceed a market value of the assets as assessed by RVO. So amount as well as first charge.
Correct. If it is not secure, government has given here 3 options. If you carefully see, if it is secure, then that is great. If it is not secure, then you can also use the tool of a CCD in the form of compulsory convertible debentures, which is convertible within a maximum period of 10 years. Here, the word used is compulsory convertible. So if they're optionally convertible, then they will fall under the ambit of deposit. This should be keep in mind while issuing the CCDs. If it is unsecure, that is fine, but it should be compulsory convertible within 10 years maximum. Third category is neither secure, neither convertible, but it is listed. Then that also will fall under the exempted deposit. So if it is a unsecured non-convertible debenture, that is called NCD, which are listed on a recognized stock exchange as per SEBI regulations, then it will be not be considered as deposit. So there are 3 options for the corporate, either to go for listed NCD or CCDs or a secure debentures.
There is a question has actually come here. Can a trade receipt be provided as a security for issuing secured NCDs? Will it require valuation to be done from a registered valuer?
I think, sir, it is covering the mentioning the assets covered under schedule 3 of that. So definitely it is assets. They can go, but excluding intangible assets. So trade receivable is definitely, it's a kind of book debt.
Gaurav, your view?
Oh, no, means actually I need to check schedule 3 specifically to see if it is an asset. Means I have not, means I need to check that. So maybe during the session I may just go through.
A trade receivable definitely an asset because it should be appearing on the asset side of the balance sheet.
I think
Right.
it's classified under had current assets.
Yeah,
So
current assets.
Yeah, current assets. Okay,
Yeah.
okay.
definitely it is assets, but register valuer should value this receivables fluctuation in the valuation.
And another
Yeah.
question has come: advance received for order, can it be termed as a deposit?
We will discuss. We will discuss.
Yeah, it is the, I got the question. It is 365 days. So I'll come to the question
Okay.
later on when we discuss that point, like
Sure.
not now.
Yeah. Okay.
Yeah. So here the main aspect is if you are issuing an optional convertible debenture which are neither listed nor secure, it will be termed as deposit. Moving forward.
There is another question is asking on the question: can CCDs be converted into redeemable preference share?
Actually, it is not relevant to topic.
Yeah, yeah, it is not relevant to the topic.
Sorry, sir. Which is the question?
Can CCD be converted to the redeemable preference share?
I think we can skip this. If Gaurav wants, we can take it later. Go ahead with the presentation.
Yes.
Okay. So next one is any type of security deposit taken by the company from their employees in the form of a security deposit, which should be a non-interest bearing, and the amount should not exceed the annual salary of the employee. So this will not be treated as deposit. But here the word the use in the rules is from an employee under a contract of employment. So there are two types of employees. First is a contract of employment. Second is contract for employment. So which are we generally call the third party employees, labor contract labor. So which this is should be keep in mind. It should be contract under employment, not contract for employment.
Yeah, a very good point mentioned by Neel. And also, if we refer to the old rules under 1975, that time there was no restriction on the amount. So
Yes.
any employee can give any amount. But now there is a restriction which says not exceeding his annual salary. So now there is a restriction on the amount.
Second is a non-interest bearing amount that is received by a company and held in trust. So here any amount received by a company which is non-interest bearing, and if it is held in trust, then it will not be considered as deposit.
Neel, one question. That means suppose we take a security deposit from a contractor or a buyer or third party, then that will not become an exempted deposit.
From a contractor
Or buyer.
for buyer.
Yeah.
Sir, it will we will discuss this in the further slides.
Okay. Okay, no problem. If the further slide is coming, no issue. Because there is also a relevant question in there. Somebody is asking, can a security deposit from the buyer considered as a deposit? If it is coming, we will take it at that time. Yeah.
So here the second is any amount received and held in trust. So before there is an amendment came in 2017. Before that amendment, the word used was any amount received non-interest bearing or held in trust. But the government has amended the or into and. So it should be keep in trust, then only it will come under exempted deposit. Otherwise, it will be treated as deposits.
Sorry to interrupt, but there is one more. I was just checking Schedule 3. In that Schedule 3, the assets that they have mentioned as current and non-current. So it includes plant, property, equipment, intangible assets, capital work in progress, non-current investment, long-term loan and advances, current investment, inventories, trade receivables. So I think so that is specifically mentioned in Schedule 3. So that can be done. Yeah.
Thank you.
Next is the most widely used, that any amount received by the company in the furtherance of business or for the purpose of business. As companies in day-to-day operation, do some trading or supply goods service, it is not possible without any advance to do the business. So definitely any amount received by company in the for the purpose of business, it will not be treated as deposit, subject to such advance for supply goods or service are appropriated or set off within a maximum period of 365 days. So it will not be termed as deposit. Second is say for a real estate sector, the builder or contractor is
sorry to interrupt, Neel, but this is one point that we need to discuss, because we may either get questions on this point, because this 365 days is crucial from the perspective of accounting as well as company law. There is general presumption that we have to refund within a period of 365 days. If you receive an advance, then you have to. So that is not the case. Here, there is only a reference of appropriation, which means that you have passed necessary accounting entries and allocated that amount to that particular advance. That's it. If a company or an entity is GST registered, then this allocation takes place in that month or the next month. But if it is unregistered, then it is necessary that you allocate that and you account for it in the books of accounts. But it doesn't say that you have to repay it within a period of 365 days. Only thing is, only if you don't account and allocate it in the books of accounts within 365 days, then on the next day it becomes deposit.
It should be adjusted against accounting treatment. So next,
Gaurav, just give the example, appropriation. Technical exam they came.
Okay, so just for the purpose of example, maybe I have booked a particular hotel on a particular day, and I have given advance to the hotel, which is a company, whether a private or a public company. Now they have accepted that as an advance because I booked it, say, around 10-12 days before. Now, after on that day, maybe I don't go, or I don't avail the services of the hotel for some reason. So in the books of accounts, it still remains advance on that day also, on later also. And because they are not accounted in my name, as per our understanding, if I don't go on that day, then my amount is forfeited. It means I am not able to claim it. Now, still after 31st of March, the amount still lies saying that advance received from customer. But from which customer, what amount, on which day, that is not done. So that amount which remains unallocated, unaccounted, that will be deposit. But if maybe I book today, and on that day only the accounting entries are passed, and the amount says that yes, it is against me and for that amount. And when I avail the services or I don't avail the services, it is still showing that amount has been received from me. Basically, government doesn't want any unaccounted, unappropriated amount in the balance sheet. Otherwise, anybody can give money and say that, yeah, this is advance for the service. That is probably the intention.
Yeah, and further to add on this, if say for between this bar and supplier or seller, there is some dispute which goes into the court of law, then during that litigation proceeding, the this days of 365 days will exclude it of the legal proceeding goes away. So it will not be counted in 365 days. Next is any advance against immaterial.
There is a question.
Yeah.
There is a question in chat box. Please take it, Mr. Bala.
Non-interest bearing deposit received by our dealer or for becoming our dealer, can it be termed as a deposit?
Not in the present clause, but there are some other clauses under that also, and also under the non-interest bearing clause also it can happen.
Similarly, can a security deposit from the buyer considered as a deposit?
Security deposit from the buyer, yeah.
Yes, it is exempted, sir, because if you see in the next slide, I will cover this.
Okay.
Yeah.
Security deposit for the performance of contract. If you see the third one.
Okay.
Yeah.
Okay. We are discussing. Okay.
And there is one more point: credit note.
Yeah. Whether the credit note issued by the customer and remained outstanding or unsettled for more than 365 days, is it a deposit?
Yeah, means credit note. It means that probably you have paid something in excess and you have not got the money back.
Yeah, correct.
But how is it important is how that has been accounted in the books of accounts. That is important over here. But if it is properly accounted, then the law doesn't say that you have to refund within 365 days. So if it is accounted or it is against your name in the books of accounts, then it will be an exempted deposit.
If advance is taken for the provision of services by a company from the client companies for less than 365 days, whether this will be considered as an exempted deposit and required to be reported under DPT.
Okay. If advance is taken from the provisions of services of company from and companies. Yeah, yes, there is no restriction actually. Means in fact, even if we take the service now and there is no understanding specifically, but we pay after a long period of time, then there is no restriction per se.
There is no restriction, sir. Just they need to check the accounting treatment, that it should be adjusted within 365 days. That's it. The law is not saying you have to refund it or utilize it within that period.
That's it. Proper accounting is required to be done within a period of 365 days to fulfill this requirement. That's all you are saying.
We need to check the nature of service.
Another one question is there. Not sure if this is covered. Can you throw some light on any amount received by a company from any other company? Is it ICD covered in this?
Sir, already discussed.
Yeah, it is. We already discussed.
We already discussed.
It is already we have discussed. It is actually intercorporate deposits, ICDs. Yeah.
So just to give one more example in this 365 days, means the example which I gave of an hotel was one of the hotels in Goa, and they used to receive online bookings, and people used to come or they not used to come or claim. So that entity was GST registered. So whenever they received the bookings, it was obviously an invoice that was raised and it was appropriated. So it was well accounted for. The question was that there were many clients who didn't claim their services of that hotel or visiting the hotel, especially because of COVID. So the question was, what will happen to that amount? Do they have to refund that money within 365 days, typically in the case of deposits? So yeah, so this is a very relevant question. Or you can take one more example. Company has bought a capital asset, a machine, and say they have bought it today, and payment will be done in installments over a period of 36 months. Now, it is not that the question of deposits would be there. So,
yeah. Next is any advance received against a consideration for immovable property. So, say for in a real estate sector, if a contractor builder is constructing some property, if he is taking advance from the flat proposed buyer, we can say, and if it is there is no such limit to adjust in 365 days, but it's a type of a long-term capital project. But here there is a clarification which says that if after accepting the advance, if later on it happens that the builder has no such approval for building the project, say for under RERA or under local authority, then it need to refund the said advance within 15 days. Otherwise, it will be treated as deposits. So if there is no such approval to deal with such project or in the property, and if advance is not refunded after 15 days, then it will be treated as deposits. Then security deposit for the performance of contract for supply of goods services, it will not fall under deposits. Then any advance received for the long-term project, say for infrastructure project or building any hospitals, schools, for supply of capital goods, so it will not be treated as deposits. Next, say for a future service, you are receiving advance in a form of future service, say for warranty or maintenance, then it will not be treated as deposit as far as you are giving that future service as per the business norms which are in the market, or maximum 5 years, whichever is lower. So as per your business industry norm, if you are you are going to buy a refrigerator or any washing machine, then generally they provide a warranty of 5 years, because this is the maximum term that you can receive for the providing future services. But if your industry norm is less than 5 years, you need to follow that.
yeah, just to add one point, we have quite many electronic stores that we buy extended guarantee. So basic guarantee is for 1 year or 2 years, any electronic goods, and then you pay some more amount, say Vishal sales or I don't know which sales, but yeah. So they ask for an extended guarantee for say 2 years, 3 years, washing machine or any electronic item. So if you pay that to a company and that is for a maintenance, which is a future service, but only for up to 5 years, then it would not be that amount will not be a deposit. It will be an exempted deposit. So that
and the
needs to be
companies who are actually saying that we are providing warranty for 7 years, what happens?
then up to 5 years it would be exempted. After that it would be, but to actually maybe to address this issue, they give warranty not in the form of a company for 7 years, so that they come out of deposit rules.
Okay.
Because the maximum term is used is 5 years, or as per your general business standard practice, which is lower. So maximum is 5 years. Beyond that, you cannot extend. Then any advance for the subscription towards the publication, it may be physical in interest form, or any advance received as allowed by a sector regulator.
Yeah. So sorry to interrupt, but with respect to this subscription, like typically we have Economic Times Prime Edition, or we have Business Standard, or Bloomsburg Quint and all. So all these take for 2 years, 3 years, or even Live Mint and all. So all these newspapers take for that period. So that would be a valid subscription, not deposit.
Yeah, many magazines, they take a lifetime subscription.
Yeah, lifetime subscription. Yeah. But that that lifetime is actually a lifetime of the service that they are rendering. So yeah. There is a question. If 5 years exit,
if 5 years exit, it is still under the performance of contract. No, I'm not very clear. What is the performance of contract?
No, I got it, sir. In the clause 12, which he is referring to, there is a clause C, and that in that clause C, it says as a security deposit for performance of contract for supply of goods or provision of services. So I think so he's reading that clause and the clause that we are referring. Yeah, I think yes, but if it is for warranty, then not. But if it is for the security, then yes.
It should be existing service, not in the form of future service.
Yeah, that could be the difference.
Moving forward, so in a company, if some promoter bring some capital, infuse some fund by a loan, so whether it will be treated as deposit or not. So the answer is yes also and no also, because we need to check the 3 condition mentioned. See, if a company goes to the bank for the purpose of availing loan, then if the bank is mandating or giving the loan conditionally, based on that, your promoter of the company should also bring some fund, so that we can have a trust on the project. That project will bring some cash flow or inflow. So if the bank is stipulating mandatorily in the agreement that the promoter has to give some fund by infusing in the company for that project or whatever reason, or promoter's relative also, then it will not be treated as deposit. Second condition need to be fulfilled. All 3 conditions are and. Second condition is the loan should be unsecured. Here loan means loan brought up by promoter and not from the bank. Bank loan may be secure, unsecure, but the loan brought by promoter should be unsecured loan. It should not be secure on the company's assets. And third most crucial condition is the unsecured loan brought in by promoter should be repaid either before or at the time of repaying the loan of the bank. If you have paid the loan of the bank, and if in our books of account is reflecting the unsecured loan from promoter, it will be treated as deposits. So loan should be repaid along with the bank loan or either before the bank loan is repaid.
So that means, in short, till such time the bank or financial loan is repaid, then it enjoys the exemptions. So the moment the loan is repaid to the bank or financial institution, and the loan given by the promoter or his relative remains, then that will become a deposit.
Correct. Correct.
Yeah. So I would just like to add, because I have come across this situation for quite a few companies, private as well as public companies. See, this is the only provision I feel in the deposit rules which talks about promoters, not shareholder, not director, but promoters. So for that, we need to refer section 2, subsection 69 of who are promoters. So I'll just refer to that part. It says who has been named as such in the prospectus or has been identified in the annual return. That is first. Or who has control over the affairs of the company directly or indirectly, whether shareholder, director, or otherwise. And third, which says in accordance with whose direction and advice or instruction the board is accustomed to act. However, it does not include any person in professional capacity. Now, practically A and B are easily identifiable in case of company, whether a private or public company. C is something that we need to go and find out of who is actually controlling the company, but not being in the company. But anyways, so when you are seeing this part, generally in the sanction letter, this condition is given. It is, you can say, co-pay condition that along with the bank loan, you have to invest that amount. So while giving a legal opinion, always take the sanction letter or the letter on which the bank is saying that you need to pay. That is, the promoter need to bring in the money. This money, obviously, as rightly mentioned, it will be unsecured loan. It may also happen that the company may bring it in the form of share capital or preference shares or in any form. Then obviously the question of deposits is not there. But most important part over here is that agreement is there, not the loan agreement, because loan agreement will be given after we bring in the money. But who brings in the money is very important as promoter. So the people who are bringing the money, you have to check whether they are there in the, typically in case of private company, there is no question of the prospectus and all. So you need to check the annual return of who are referred to as the promoters or who is controlling the company, which is in point number B. So this is a very important point. As mentioned, all three conditions are very important. Yeah, I think there is a question. Loan received from independent director be treated as exempted deposits? Yeah, there is no restriction per se. It would be an exempted deposit, but the most important part is his independence should not get affected. So you need to check the conditions under section 149 subsection 6.
Correct. You're absolutely right.
Otherwise, he will give loan, but he will become not independent.
Yeah, he will lose his independence.
Yeah.
He will become a non-independent director.
Yeah. I know because there is one clause which talks about loans to company, loans to promoters, promoters relative, associate company and all. So yes, there is a provision on the amount to which there is a transaction.
I think there should be not any material pecuniary relationship between the ID and the company. So
correct.
Also get triggered. So apart from ID, you can take, or as far as the IDs independents are not getting biased. Moving forward, next one is the most widely used in this current business scenario is a startup company. So startup company are the generally fintech company, tech-based company, which are providing employment, and government is giving so much of benefits and exemption to the startup companies. So if a startup company is always a private company. It is not a public company or listed company. Startup company is always a private company. So if startup company is raising some fund, receiving some money from any person of minimum of 25 lakh rupees, the amount should be at least 25 lakh or more. And it should be in a single tranche. That means if you are given installments, it will treat it as deposit. It should be come upfront at a time. Second, it should be about convertible note. Convertible note means either it is convertible into the equity shares of the startup company or redeemable within a maximum period of 10 years. Here, the one should keep in mind is that it should be convertible into the equity shares. If it is convertible into preference share, it is not a convertible note. And it should be redeemable within the next 10 years. It is increased from 5 to 10 years by the Companies Amendment Act 2020. Again, these three conditions are in. So a startup company is receiving amount of less than 25 lakhs, it will not be eligible to claim this exemption. It should be of at least 25 lakhs by convertible note, which is either repayable within next 10 years or converted into equity shares. So generally, startup company are receiving money from the angel investors, or you can say alternate investment funds or venture capitalists. So they are very professional kind of investors. They know what are the pros cons to invest in the company. That's why government has given this exemption. So being an individual investor, you always individual investor bring a small amount. That's why they are deliberately excluded from this exemption. Any views, sir, Gaurav sir, on this?
No, actually, I don't mind giving any views, but we can expect some more questions because the concept has been deliberated. Basically, more than 25 lakhs and convertible into equity. That's the crux, and also within a period of 10 years. So we have different kind of instruments that come up for private startups specifically. We have convertible notes. We have ISAF notes also, which is also borrowed from US as a. But yeah, so all these, if we satisfy the conditions, then it becomes the basis for report.
Then the remaining categories are Nidhi company as a incorporated of section 406 of that. Nidhi companies is mainly involved, born for the purpose of accepting and giving deposits to its members. That's why Nidhi company has been excluded. If you are subscribing to the chit fund, that is also not covered. If any money is received under the collective investment scheme under the SEBI regulations, then it is also exempt. Any amount received from the venture capitalist, the alternate fund, mutual funds, REIT, INVIT, all that are regulated by the SEBI. That's why this has been intentionally exempted from these definitions.
Yeah, so just one point with respect to the AIF and mutual funds, or probably more specifically about AIF, or in fact, all the three, means all the points which are mentioned on the slide. Here it doesn't say actually any amount only. It again goes back to the definition of deposit. So there was one question asked that if AIFs invest money in the form of share capital of a company, whether it becomes exempted deposit. So that is not the case. So it says about as the clause starts, which is given in the rule 2.1, it says any receipt of money by way of deposit, loan, or any other form by the company. So that any other form, we have to read it in line with deposit and loan. Therefore, not all amount becomes deposits or exempted deposits. So if amounts are given in the form of an loan or deposit, then it would be an exempted deposit. Interestingly, there is no monetary limit on these transactions. So so that is the case. Yeah.
There's one question has come.
Yeah.
For class 17, any reason the amount of rupees 25 lakhs will be exempted only if received through the convertible note? Any implied rationale which we are missing?
Sorry, sir, I didn't get the question clearly.
The 25 lakhs or more money, if it is exempted, they are saying if there is any rational reason which we are missing or something, that's what he's asking.
I already told rational is that the amount is capped 25 lakh because the money of small investors should not be get any risk. The amount invested, hefty amount is invested by the HNI, right? Or any alternate funds, the angel investors. They are already well aware about the constitution of the company, their promoters, directors. That's why they have been exempted. If any small amount is received by startup company, then there is a huge risk that the money may not be repaid. That's why government has keep the higher limit.
Yeah, actually, I don't know the exact rationale of why exact 25 amount as minimum, but if there is any probably maybe if the participant who is asking, they can also answer that why, because I am also not aware of why 25 lakhs as the minimum. But if there is anything that probably we are not aware.
If I can connect correctly, in the AIF regulation of SEBI 2012, For
Yeah.
the AIF, there is a limit that they should invest at least 25 lakhs of their corpus in the startup company. That's why from that limit, the government is bringing in order to align both the laws.
Okay.
That is maybe the connection.
Okay.
And followed by, there is another question to Neel. Not on the amount, but on why only convertible note?
Correct. It should be from by convertible notes. Definition is also given. Convertible note is, if you can see the explanation, it means any form of instrument evidencing a debt, which is either convertible or which is repayable within 10 years. It should be by convertible note.
Hello, Neel.
Yes, sir.
Neel, this is Raviraj here from Sipla. The question was not on the amount, as Gaurav have already explained. It's regarding why only through convertible note. Like we have any other mode, we can receive this 25 lakh through any other mode, but it will be exempted only when we take it through convertible note. So any rationale that we are missing on this? That's the ask.
Sir, in which other instrument you are saying in particular? Because the shares, debentures are already covered. Equity share, preference share, debenture, bonds are already covered in the previous slides. So the remaining instrument is, I think, is only the convertible note, and that is only for use for the startup company. Not any company can issue this convertible note except startup company.
I think, Neel, the question is why for startup company they have mentioned convertible note. Am I correct? That is your question, right?
Exactly, ma'am.
Why only for startup company they have mentioned convertible note? That is the question.
Ma'am, I think if you see the FEMA law, in that also there is a reference of convertible note. Only for the startup company, this is you can say a kind of a unique instrument that is exclusively available for startup company. It is just like a venture.
No. I think, as per my opinion, sir, I think since startup company, they should not be accepting deposits as such, but they get this funding, then they should convert it into some shares. So it is basically contribution towards capital. And in that reason, they have specifically mentioned convertible note only. This is my opinion and understanding. Because for startup company, it should be contribution towards capital only.
I think in the beginning, startup company, they seek some seed capital because they want to establish their business. So they find some strong investor who can support in the board also in the form of infusion of fund also. That's why the convertible note is used, so that it is ensure that later on if the shares.
So I will put that way, for startup company, either you bring as a capital or you bring as a funding. Now to get the equity proportion, because they keep on offloading certain proportion and the valuation. So they want to get the valuation later on. So for structuring purpose, this can be, I think, they have allowed this credit note. So the same can be used for structuring purpose. This is my view.
What you're saying, Dipti, it seems to be logical. Yeah, as you rightly said, it is actually more of a contribution towards the capital over a period of 10 years to overcome the establishment from the business, etc., and other things, and ultimately it gets into the capital. That seems to be the logic.
So it's one kind of that instrument. You can say the old wine in the new bottle. This is just a nomenclature is used. I think convertible notes. It's like a convertible debentures or.
No. It's not about instrument. It is not about instrument. It is about the structure of startup company.
Correct.
And it says that because for startup company, equity offloading, their contribution, dilution is a crucial thing, and the valuation. So if you give this option of taking it as a at present kind of a funding deposits, which is exempted, and converted in future, so that if they want, the valuation will increase in future. So accordingly, the equity offloading will done. So this helps in structuring, and that's why. I think this is my view. I think enough we discuss. I hope we somehow discuss and given the view.
Yes.
Okay, and we can go ahead.
So this all the transactions we have discussed in the previous slides, These are the category of exempted deposit that will not fall under the definition of deposit, but we need to report the same transaction in form DPT3 with the ROC. Now let's understand how to accept deposit, what is the procedure, and what are the other terms conditions. So the main chapter which is governing under the Companies Act of Deposit is Chapter 5, from Section 73 to 76A. Section 73 talk about prohibition on acceptance of deposits from public, and 76 allows certain eligible company to accept deposits from public. There is a section 74 also and 75 also, which is right now in this time have no relevance, because that is a kind of a transitional provision when the Companies Act 2013 was introduced. So at that time, if some amount is outstanding when the Companies Act came into picture, so you can apply to, you have to repay the said existing deposit within some period of 3 years. Otherwise, you can apply for the extension to the NCLT. So that is not relevant. That's why I have not covered here. And definitely the companies acceptance of deposit rules 2014. These are the main provisions which govern deposits under Companies Act 2013. So first, check the applicability to which companies these regulations or sections will get triggered. So as per the first provision to Section 73(1), read with Rule 1 Subrule 3 provides that the provisions of this Chapter 5 shall apply to a company other than the following companies: banking company, non-banking financial company, and housing finance company. These three companies are exempted by central government through notification, because if you see this exempted category are their ordinary business is to accept deposits from public. If they are prohibited to accept deposits, then they cannot run their business. And already there are strong regulation under the RBI's framework for the banking sector. That's why they are exempted from complying with the companies. Except from
sorry, but this exception even applies to exempted deposits. So these companies are not required to file the DPT3 form.
Correct. The whole Chapter 5 will not apply. No, not only the sections, the rules will also not apply. Correct, sir. So let's understand the main governing section, the charging section under the deposit is Section 73 and Section 76. Section 73, it's a kind of a negative section, I can say, especially subsection 1, which puts a ban or embargo on the company from accepting renewing deposits from public. It states that no company shall invite, accept, renew deposits under this act from the public except in a manner provided under this Chapter 5. So it is a restrictive section which restrict the company from accepting deposits from public unless you comply with the Section 76. While Section 76, which is an enabling provision which overrides Section 73 and which enables a company, or I would rather say eligible company, it should be a public company which fulfills certain criteria of net worth and turnover, that it can accept deposits from the public. This is the charging section which governs the deposits. Any question?
I don't see anything on the chat box as of now.
Okay, so let's first understand what is eligible company. Eligible company is defined in Rule 21E. Read with Section 73. Eligible company means definitely a public company having either net worth of at least 100 crore or a turn of 500 crore. So there are two criteria. Either you should follow in any one. Either your net worth is 100 crore or turnover is 500 crore. Then you're eligible to accept deposits from public. However, you need to take a prior approval from the shareholder by a special resolution, and the said resolution should be filed with the ROC before making invitation to public for acceptance of deposits. So you need to file the MGT 14 with the ROC before issuing the circular of deposit, inviting deposit from public. However, there is a provision which says that if you are accepting the deposits within the limit of Section 180 subsection 1 clause C, that state that it limit the borrowing of money, right? So if you're accepting deposit within that limit, the limit is your paid up free reserves and security premium account. If you're accepting deposit within this limit, then only OR is sufficient. You need not be required to pass the special resolution. This is a relaxation given for accepting deposit within a certain amount. That is your paid up free reserve and SP account. Here a question may arise that as per the section, it is mandating that you need to pass the resolution and file the same resolution with the ROC before making invitation to public. But the proviso exempt the company from passing SR and state that only OR is sufficient. So whether we need to file the OR also with the ROC or not, because as per section 117 of that, only the special resolution pass, it should be filed with the ROC in form MGT 40. But if you read in letter and spirit, so the legislature is wanting that you should pass the resolution, irrespective it is a SR or OR, it should be filed with the ROC before making invitation to the public. That is the main essential part. The emphasis should not be given to which type of resolution. It is a special, ordinary, doesn't matter. You should file the said resolution with the ROC before making invitation to the public. As per my understanding, this should be complied with. Gaurav sir, any other views on this?
Oh, no, nothing specific on this.
Yeah. So eligible company is only eligible to accept deposits from public. Next one. So next one is deposits from members. So section 73 subsection 2 enables a company from accepting deposits from members subject to passing of a normal resolution or a resolution at the general meeting and fulfilling the following conditions. There are 6 conditions, 6 clauses A to F, which should be complied with if you are accepting deposit from members. And the said condition also apply to accepting deposit from public also. So whether you are accepting deposit from members or public, the same condition you need to follow. The first condition is you have to issue a circular to the members in form DPT1. In DPT1, there are some information you need to give, like your financial position, your credit rating obtained, number of depositors outstanding, total amount of deposit outstanding as on date. This information you need to give in the circular to the members in form DPT1. However, before issuing this circular to the members, you need to file the DPT1 with the ROC 30 days advance before issue of circular to members. That means before issuing circular to the members, at least 30 days in advance, you need to file the same copy in form DPT1 with the ROC. Then only you are eligible to issue the circular to the members. Third condition is that
there is a question has come here.
Yeah.
Yes.
How will a company comply with the deposit rules when an exempted deposit becomes deposit in virtue of the default? Because issuing a circular to the members, filing the copy of the circular with ROC, etc., are a prerequisite to avail a deposit.
Sir, I think if I am understanding the question correctly, it is saying that I have accepted exempted deposit and I have made some breach, and so now it will be treated as deposit.
Yeah.
This is the question?
Yeah. Because he says very clearly, company comply with the deposit when the exempt deposit becomes deposit by virtue of the default.
Okay.
Yeah, so actually, practically it is difficult to comply with the condition which is given in section 73(2). The only option, or though it becomes deposit, obviously it is non-compliance of section 73 and the rules. Therefore, the penal provisions will trigger immediately. But it would be difficult to comply with the rules because all these are prerequisite rules. And intention of raising, not raising, I mean to say, but intention of having exempted deposits was not going for deposit. So penal provisions would trigger then issuing the circular, though it is the case.
Yeah, no condition can be fulfilled here. In this case, definitely, as you rightly say, penal provision. Maybe the company may have to go for the compounding of the offences and get it compounded. That is what the only solution can be done.
Yeah. So third condition, the company which is accepting deposits from members of public has to open a deposit repayment reserve account in a scheduled bank, in a separate account, scheduled bank, and have to deposit at least 20% of the deposit amount maturing during the following next financial, by maximum on or before 30th April of that year. Say in the FY 22-23, my deposit, I have accepted the deposit, and in the next financial year, my deposit maturing is say for 100 crore. So
following with the last question, there's one more question has been raised by the participant. Then in that case, how will we actually compound? Because how will we actually make the offense good?
Sorry, sir.
The earlier question, they raised the question, no, because of the exempted deposit, because of the default, we cannot comply with it. So here he says, okay, then in that case, how will I compound? Because how will I make a good this offense good?
Sir, it is a private company or a public company?
That we need to ask the participant.
If it is a
No,
private,
but I think, yeah, we need to, sorry. Yeah, we need to refer section 76A, capital A. It says punishment in the case of contravention of section 73 or section 76. And obviously read with the rules, because rules have got separate provision for that. So I feel that though I have not gone in detail right now, but there is a reference of imprisonment over here. Then in that case, the special court will trigger under the provisions of compounding of offences.
Shivkumar, are you there? Would you like to say something?
Hello.
Yeah, Shivkumar.
I think, Gaurav, that this penal provision will, as regards imprisonment, mens rea will be quite pre-requirement. So I think it is not a imprisonment, since it was never intended. But yeah, possibility is there, but the thing that it is a last resort kind of thing.
Right.
But of course, compounding by payment of penalty will be sure.
Hello.
Yeah, yes, Shivkumar.
See, yeah, my question was, see, if we go for a compounding, the registrar, the first question the registrar asks is, how have you made the offense good? So in this case, how will I say that I have made the offense good? Because I'm not able to comply anything. I cannot issue a circular. I cannot file anything because everything is done. So in that case, how do we deal with, if we go for a compounding?
sir, can you just tell which is a private company or a public company?
It doesn't matter. Say, for example, if it is a private company, I have taken the application money and I have not refunded within that 15 days, and I have exceeded that 76 day for some reason. So then that would trigger my deposit rules. Yeah. So how do I, file a circular or issue a circular? Because ROC would ask me a first question that, have you compounded, have you made the offense good? So how will I respond? Yeah. That is the question.
So I got actually, it depends on the type of the transaction which we are dealing with.
Yeah.
Now the point which you are mentioning about the share application money not refunded within time.
Yeah.
Then I feel you have made good the offense the time you have refunded the money. So you will be liable for, say, for example, you are required to make the refunded on the 75th day. Right. You have done it on the 100th day.
Right.
So you will be liable for 75 to 100 days. Right. And we have Rule 21 in the deposit rules, which talks about the penal provisions. That every company and the officer who is in default shall be punishable with a fine, which may extend to 5,000 rupees. And contravention is continuing with a fine which may extend to 500 rupees per day. So it is only fine. So it is only fine. This can be compounded.
So the only redressal is I return back the money whatever I have received.
You have to return back the money and go for compound.
And then go for compound. Understood.
Yeah.
Thank you very much.
That is a rectification only, that you have paid, refunded the money.
Right.
The deputy one.
I think the same thing we do for even RBI compounding of offenses. Right. Yes. We refund the money, we calculate the time, we calculate the days, and then we go to the RBI. So
Thank you so much.
But this is a you can say a safe transaction to say that compounding is possible, but some transactions are not reversible.
Right.
So
Yeah, then in
would
that
be
case,
the-
how do we
yeah.
do it?
Yeah,
Because if
that's
it's a
what-
huge amount,
Yeah.
and suppose if it is an immovable property and I don't have a
Yeah.
permission and there is some dispute, in
Yeah.
that case, I cannot, if I've used my money also, I don't have to have the
Correct.
funds to refund. Then there is an issue.
So that's what I think. So means we need to see it case to case,
Right.
and the facts of the case.
That's thank you so
similar to
much.
yours.
Thank you so much.
Thank you.
Yes, please.
So continue with the conditions. The company which is accepting deposits from member public has to deposit at least 20% of the deposit amount maturing during the next financial in by 30th April of that. The fourth condition is the certificate is required from the statutory auditors certifying that the company is not defaulted in repayment of deposit or interest payment. However, if the company is defaulted in the payment of interest or repayment of deposit, then auditors to certify that a company has rectified such a default, a company has made the good the default, and a 5 years has expired or completed from the date of making good the default. Here it is written that it is not that you have defaulted and 5 years has lapsed, then you are eligible to accept deposit. You should have rectified the default, and from that day 5 years will be counted. This should be keep in mind. Next condition is if you are accepting secure deposits, then you have to create a charge on the company's assets and filing the CHG1 form within 30 days. However, if amount is not fully secure, that means the partially secure, then you need to determine or disclose the fact that this deposit is not fully secure in every document, advertisement, form, circular inviting the deposit, so that the proposed depositor should know that this is a unsecured deposits. It is a kind of a risk. Before investing, he should have a rational information. The clause D, which was dealing regarding stipulating the deposit insurance for the acceptance of deposit, has been removed by the company's amendment in 2017. So right now there is no requirement to have a deposit insurance. The company need not to enter into deposit insurance with the insurance company. That has been voluntarily if you want to do so, but right now there is no such requirement or stipulation. These are the main condition from A to E that company should comply if it is proposed to accepting deposits from members or from public. However, government has provided certain exemption to certain class of private companies and also IFSC public company. So here the exemption notification dated 5th June 2015 and also 13 June 2017. Both should be read simultaneously. We state that clause A to E that we have discussed in the earlier slide of section 72 shall not apply to following class of private company. First, it is important to understand clause A to E will not apply. That means clause F, that is dealing with the security, will apply to every company. If you are issuing secure deposits, need to file the CHG1. If it is not secure, you need to disclose the same fact in your documents or circulars. Clause F will apply, clause A2 will not apply. Which are the class of company? First is a private company which is accepting deposit from members up to 100% of his paid up share capital, free reserves, and SP account. So if a private company is accepting deposit from member within this limit of his net worth, I can say, so it is if it's not crossing this limit, it is exempted from complying the above condition. That means it need not to file the DPT one, it need not to deposit the open a deposit repayment account. Also, there is no requirement to have a certificate from the auditors also, if it is accepting deposit within this limit. Second company is a startup company. As discussed, startup company are always a private companies, but exemption is given only for 5 years from date of incorporation. But if I check the rule, the government has amended or extended the year from 5 to 10 years in the rules. But the notification which is brought by the central government in 2015 and 2017 has not been amended. So there is a doubt here that for startup company, exemption is for 5 years or 10 years. So I just want to Gaurav sir's opinion regarding this, because in the rules it is stating 10 years, in section it is still 5 years.
Yeah. So rules, you are saying the startup notification rules or which rules? Deposit rules.
Deposit rules, sir.
Okay.
Rule 3, if you refer, rule 3 of the deposit rules. The second provision is exempting startup company from accepting deposit without any limit for a 10 years.
Okay. No, I'll just check in just some time and I'll revert on this. But I feel this is a very important aspect from the perspective of companies, typically the private companies, that there is a restriction on the limit on how much you can raise the money. And then there is a condition with respect to that you should not be an associate company, subsidiary company. Typically, they want to say you should not be a group company, you should be an independent company. Then only you can take the same. So yeah, but very important point which we always come across is when filing DPT3, whether acceptance of money from members, acceptance of deposit from members, do we need to report it in the DPT3? Because practically there is no provision for it. And I also don't feel that it is required to be reported. So therefore, from shareholders is not required, but from director it is required.
Sir, let me correct it if I'm not wrong. The exemption notification itself states that exemption is available subject to you intimate to the ROC by filing the DPT3 form. So you need to comply with the conditions of E2E. That means you need to pass the ordinary resolution general meeting and you need to file the DPT3 also with the ROC. The exemption is only with regards to clause E2E, that is the depository from reserve to DPT1. So you need to intimate. It is considered as deposits from members.
So yeah, correct. Sorry. So sorry for this part, but important point is where do you put it in the form? Because there is no provision in the form. So probably I would have thought that, but I would have said something. So probably you can put it if at all there is a miscellaneous clause, or you can put it with directors, but giving a note that this is of directors and this is of members. Because I don't think there is a specific provision for members.
Gaurav sir, if I'm not wrong, in DPT there are 4 radio buttons that for filing the form. One is accepting deposits from members. Second is transaction not considered as deposits, and third is both. You are accepting deposits from members also, or exempted deposits. So if you select that last radio button, then you can definitely disclose the details in that form.
Okay. So we have just got a query.
Yeah. Can a public company, that means in the bracket holding company, get an exempted deposit from that subsidiary company, again a public company, or vice versa?
If both companies are based in India, then this is possible as a intercorporate deposit under Rule 2(1).
Correct.
C.
Correct.
Should surplus in P&L account be included in the free reserves?
Yes, sir. This is
while entering net worth figure DPT3, because as per the definition, free reserve net worth only reserve transferred from surplus of P&L account considered as free reserve, and respectively. That is what it says.
Correct, sir. So as per, if you see the definition of net worth under the Companies Act, it is saying paid up share capital, free reserves, and surplus in the P&L account. So surplus is a different thing and free reserves is a different thing. But at the time of filing the DPT form, there is no separate column to include surplus. So in order to tally the net worth figure, we need to include the surplus amount in the free reserve column also. That is the only option available in the form. So although surplus is not the part of free reserves, it should be included in the free reserve.
So they mentioned there, is it?
Yes.
Okay. Because unless the surplus is transferred to the reserve, it does not become a free reserve.
Correct. Yeah. But there is no option in the form. So in order to tally the net worth figure, ultimately net worth figure should get tallied. So based on that only you determine the limit. That's why we need to include the free reserves, surplus in the free reserves. Yeah,
this is somewhat similar to declaration of dividend. From where do you declare it? accumulated profits or reserves. So, typical the question that we have.
Yeah. So the first two category of companies that are not required to comply with the condition of clause A to E is a private company accepting deposits from members up to 100% of their paid up free zone and security premium account. Second is startup company for up to 5 years from date of incorporation. These three companies should be read as or. Third category of company need to comply all the three conditions A, B, and C. First condition is it should not be associate company or a subsidiary company of any other company. Second condition, borrowing of such company from banks, financial institutions, or any body corporate should be less than twice of its paid up or a free or 50 crore, whichever is less. Say for if I am a private company and my borrowing, my paid up share capital is 20 crore rupees. So my borrowing should be twice of paid up, less than twice of paid up, that is 40 crore or 50. So whichever is less, that is 39 crore. Here we should read it is given in the section less than twice of paid up or 50 crore. It should not be read equal to twice of paid up. So if my paid up is 20 crore and my borrowing is 40 crore, so ultimately 40 or 50, whichever is less, 40 crore, it is the answer. But it should be 39 crore. That means less than 40 crore. That is the provision in clause B. Less than twice of paid up or 50, whichever is less. If it is touching the limit, then it will not get exemption. Third condition, it should not have defaulted in such borrowing at the time of accepting deposits. These three conditions, if you are fulfilling being a private company, then also you can avail the exemption of the notification. Fourth company is a public company, IFSC company. IFSC company, which is a company that is set up under the Special Economic Zone Act, SEZ Act, under the IFSC Center. It is an unlisted company, but is accepting deposit up to 100% of its paid up and free reserves, then also it can avail the exemption. But subject to, as already told, DPT3 filing is must with the ROC. So this class of company can avail the exemption subject to filing of the DPT3 with ROC and complying with the conditions. Any questions here?
There is a question. It says, how does Section 8 company not having share capital report its capital received in the form of corpus in DPT3 for net worth calculation?
So basically, Section 8 companies are generally limited by guarantees. Very rarely you see Section 8 companies are limited by shares. So in that part, you need to take the corpus as a share capital and you have to count the limit based on the corpus. It's treating as a share capital. That is the only way to calculate this limit. Otherwise, there is...
Sir, I feel in the case of the net worth, it will be only the free reserve which will be part of the point that we mentioned in DPT3. Obviously, it doesn't have share capital. So whatever is in the free reserve, it will be.
So there will be a surplus which is generated, which is the free reserve.
Yeah.
Okay.
Yeah. So there is one more question, sir.
Yeah. Advance received on sale of immovable property by manufacturing company. Is it exempted deposit?
Sorry, can you repeat, sir?
Advance received on sale of immovable property by a manufacturing company. Is it exempted deposit?
Yes, sir. Definitely, it is falling under the exempted list of deposits.
Yeah. So I'll just refer to the point actually what he's mentioning, because it is an immovable property by a manufacturing company. Over here, if you see in that Rule 21C, Clause 12, Clause B, it says that advance accounted in any manner whatsoever received in connection with consideration for immovable property under an agreement. So this is possible, but it doesn't talk about manufacturing or any type of company. So it will be exempted deposit.
The main thing need to be kept in mind is consideration is against immer property. If it is
Yeah.
satisfied, then it will be exempted deposit. You need not to check what is the constitution of company
Correct,
manufacturer.
correct. You're right. Absolutely, you're right. Anyway, Gaurav, you got a thanks. Gentlemen, thank you for the answer. Good.
Thank you.
Yeah. Go ahead, Neel.
So moving forward, now let's see. Up to which certain limit I can accept deposits. So rule 3 is providing limits for acceptance deposits by both the companies, eligible companies, that is from public and from members also. First, we'll discuss about eligible company. So there are two modes for eligible company to accept deposits from members also and from the public also, other than members. So there are two categories of eligible company. One is a non-government eligible company. Another is a eligible government company. So first, see what is the limit for a non-government eligible company. A non-government eligible company can accept deposit from members up to 10% of its paid up, pre-reserve and SP account. And from public, it can accept maximum up to 25% of the paid up, pre-reserve and SP account. So the maximum cap fixed aggregate limit is 35%. From members, you can take deposit up to 10% of your paid up, pre-reserve and SP account, and from public, you can accept up to 25%. That is for a non-government eligible company, which satisfy the criteria of turnover and net. Now, if I'm a government company, by virtue of a government company, I will not get this exemption. I should fall under the eligible criteria of turnover net worth. Then only I can take deposits. For government company, there is no such cap mention or bifurcation mention. From members, you can take so and so much, or from public, you can take so and so much. The overall limit is 35%. Either you accept from member 20% or from public 30%, doesn't matter. Over limit should not exceed 35% of the paid up, pre-reserve and SP account. That is for a government company.
Gaurav, there is a question is there. What would be the due date for filing a form DPT3 in case private company accept deposit from members under this exemption category? But I don't think
So it will be the same.
the
Yeah.
due date will not be different from anything. It will be 30th of June every year for
Yeah.
DPT3 filing, irrespective of whatever the transaction is there.
Right. It will be the same.
Correct.
Yeah. And there is one more.
Yeah.
Yeah.
That the exemption to startup means any amount can be taken as loan from the members. On the normal private company, it is limited to 100% of the paid up share capital, free reserves, and the securities premium account.
So I'm coming to that part also. Just
Okay.
the further slides.
Okay, you are going to discuss. All right.
So this is the limit for eligible company or accepting deposits from public and members.
Okay.
Now, acceptance deposits by public company which does not satisfy the criteria of eligible public company from members. So as per section 73 subsection 2, normal public company which are not eligible to accept deposits from member can accept deposits from members. Up to which amount? So if I'm a public company, non-eligible public company, I can accept up to 35% of my paid up, pre-reserve security premium account. There is another public company, IFSC public company. The exemption is given to IFSC public company that it can accept up to 100% of its paid up, pre-reserves and SP account. This is a two type of public company, non-eligible public company. They can accept deposits from members up to 35% and for IFSC public company 100%. Now let's see.
One more question is here. What about the money received by a private company prior to 31/3/2014?
Yeah.
On which date, sir?
31/3/2014.
Okay. So there is a clear section says that section 74 deals with that part. It says that as on the effective date of the company's at 2013, any amount outstanding, it should be repaid within next 3 years from the due date or the due date to the reserve.
No, but that is there for deposits.
Correct.
He's talking about, I think so, exempted deposits, because in the next part he says that because as per MCA circular, amount received from the member prior to 31st of March 2014 is exempt and will not be treated as deposits.
Deposit.
Yeah. So there, I think so is a judgment of the NCLAT in the case of, I don't remember the exact name, but yeah, there is a judgment which talks about deposits, but not obviously not about exempted deposit. It says that when there is a deposit of the previous year, then there is a provision also in the act based on the judgment, I think so. So basically the crux is that the deposits under the previous law will be deposits under the previous law, and deposits under this law will be the deposits. So applying the same, you can say same principle, we can say that they remain exempted in this law, but you have to report them in the DPT3 in this law. This was actually the question when the deposit rule was introduced, I think so 2018, and they introduced DPT3, that what do we report this? But in my view, yes, we have to report, because if you see even the balance sheet, it will be reflected in the same place where the exempted deposits are there in this act also. So you have to report the same.
Saying, let me correct if I'm wrong. Subsidy of the government company, which is private company, can also under the ambit of 35% if it is a deemed government company.
Sorry, sir.
He says subsidiary of the government company, which is a private company, can also under the ambit of 35% as it is deemed a government company.
Yes, correct, sir. If you see the definition of government company, it state that if the majority of paid up capital is held by central or state government or a government company, it will be under the purview of government company. So it has to comply with this limit of 35%. We should satisfy the eligibility criteria of turnover and net worth. Then only it can accept deposits. Otherwise, it should be a private government company, not eligible government company.
Does the exemption to startup means any amount can be taken as a loan from the members, and for normal private company, it is limited to 100% of the paid up share capital, free reserves, and the security premium account?
Sir, I'm coming to that part. Just
Okay.
give me a moment. Yeah. So deposits from members by private company. So there are two categories of private company. One is normal private company. As already discussed, it can accept up to 100% of its paid up capital free on a security account. And another is a startup company. Startup company, here it is up to 10 years it can accept from their member. There is no such limit. You can accept exceeding your 100% of paid up free or SP account also. There is no such limit. There is an exemption for startup company up to 10 years from incorporation. And second is a conditional private company which satisfy the condition of borrowing and which is not associate company, subsidy company of other company. So for this two private company, startup company and which satisfy the three condition, they can accept deposits from their member unlimited. There is no such limit. For normal private company, up to 100% of paid up freeze or SPF. If they want to avail the exemption of the clause A to E notification of 2015 and 2017.
Yeah, just I would like to add one thing is that now what has happened is this private company is not just a private company now. There is further bifurcation, like a startup company or different types of, or OPC, right? So there are different colors to the private company. So what is important is that even if you go for a startup, you are ultimately a private company only. So you can claim exemptions of a private company as well as a startup company. Same for OPC or same for any other kind of company, which may be an IFSC company.
Yes, the ultimate character should be a private company. If you're a startup, then you can take more advantage, more benefit of the notification. Otherwise, already you can take the benefit of ordinary private companies exemption of 100%. Next is what should be the tenure of deposit and what should be the rate of interest. Rule 3 governs the terms condition for acceptance of deposits. So the minimum period for deposit should be 6 months. You cannot accept deposit that is repayable on demand or a period less than 6 months. So minimum lock-in period, we can say it is a 6 months. Either you can accept from member or public, doesn't matter. For both this, yeah, the condition is same, rule is same.
There is a question is for you on this. Under Rule 3, Sub-Rule 3, the exception criteria are as, or, and, not as, and.
Sorry, sir.
That means that the three conditions are not required to be satisfied if the company is a startup. If any otherwise, please clarify.
Sir, as already I have discussed, there are three categories for exemption. Yeah, so there are three categories. One is normal private company, they can accept 200%. Second class of company is a startup company. There is no such condition to accept deposits from member. If you are a startup company for 5 years, and if you're not falling under the class of company A or B, then you have to follow these three conditions. You got the point? If you're not coming in the point 1 or point 2, then you have to follow the condition of ABC.
Okay.
If you're a startup, there is no requirement to follow this condition. There is three are separate kinds of private companies. I hope it's clear.
He says, I believe even startup company will have the limitation to accept the deposit since it is a private company.
Yes, sir. That's what, sir. Definitely.
That's what I
It will
told.
have.
This clearly mentions for startup company, there is no limit to accept deposits from their member up to 10 years.
It is, sorry to interrupt, it is selling that from the member. So startup company, the member means shareholder, means initial setup, the person who started startup company. Not only that, there will be investor, which can be AIF or private equity and all that. And that's why they have mentioned the limit. And again, no limit. Because in startup company, who will give deposit easily? And it is members themselves whose shares are there. So that's why the limit is not mentioned. The intention is to provide support to startup. They have been given freedom to raise the fund so far possible. This is my view. Please.
Yes, ma'am, I agree with you. In order to promote the startup company, government is giving this exemption. So, sir, answering to the question, there is no separate condition that need to be followed by startup company if it is recognized as startup for up to 10.
He is referring the earlier section because as per the earlier section 58A, the money taken from the members was not treated as a deposit, and therefore there is a MCS circular in 2015 that such money taken from members was not treated as a deposit, and therefore there is a MCS circular 2015 that such money taken will be exempt in the new account and will not be treated as a deposit under the new section.
Yeah, that is correct, sir. Means therefore we have, so it remains exempted deposit even in this law.
Correct.
Only thing we have to report it in the DPD 3.
That is right. That is
Yes,
right. You are absolutely right.
Yeah.
Shall I move forward?
There is no specific section or rule provided to startup companies for accepting the monies in the form of the deposit, in my view.
Correct procedure. You can follow the standard procedure. There is no DPT1 or any type of filing. So what we are discussing about the tenure of deposit, the repayment period should be at least 6 months. However, for to meet the working capital requirement of short-term fund for the business, there is a provision which says that companies can receive deposits for a repayment period less than 6 months. If the acceptance of deposit up to 10% of your paid up freeze on a security premium account. Only for working capital purpose of short-term fund requirement, you can accept up to 10% of your paid up freeze or SP account for less than 6 months, but it should not be repaid earlier than 3 months. So you can accept 10% of your threshold for minimum 3 months up to 6 months. This is an exemption. Otherwise, the minimum period is 6 months. Maximum period for deposit is 36 months. Deposit cannot exceed for repayment more than 36 months, whether it is accepted or an renewal also. interest rate for the deposit should be as prescribed for NBFC by the RBI. That you need to check. Maximum rate of interest. Now, if some depositor want to withdraw his money prematurely due to some personal reason, so whether it is allowed or not. So rule says that any depositor, if the company allows, then he can withdraw the money prematurely, but not earlier than 6 months. As a minimum tenure of deposit should be 6 months. He cannot withdraw money earlier than 6 months. However, if he is availing or withdrawing the money prematurely, then the interest rate payable on the such deposit shall be reduced by 1% from the original rate. So the company will deduct 1% interest if he is withdrawing the money before the maturity period. There are two scenarios in which this condition will not apply. That means they can withdraw money before 6 months also without deducting of interest. If it is solely for the purpose of the compliance with the provisions of Rule 3, that is the limit, if companies accept a deposit exceeding its limit and if it's repaying to comply with the rule, or in order to for the war risk any emergency declare as per the constitution. So in these two cases, they can withdraw before 6 months also without compromising the interest rate. Otherwise, it is not allowed earlier than 6 months. Now, if a depositor want to advance renewal the deposit in advance before the expiry period, before the maturity period. So yes, a company can permit depositor to renew his deposit before the expiry period, so for availing the higher rate of interest. However, the higher rate of interest shall be payable only if such deposit is renewed for a period higher than the unexpired period of such deposit as per the rules. Say for example, my deposit period is 36 months, maturing on 36 months. On completion of 30 months, a depositor want to renew its deposit for a period of 12 months. So ultimate period is 48 months. So here it is what the law is saying: if a deposit is renewed for a period higher than the unexpired period of deposit, so my unexpired period was 6 months and I am renewing deposit more than 6 months, that is 12 months, then only you can avail the higher rate of interest. In short, the period of renewal should be more than the unexpired period of the deposit. And here, if the period is less than 6 months, then it will be ignored. And if it period is 6 months or more, it will be rounded off to 1 year for the purpose of interest calculation as per the rules. Now, a brief procedure I have given here for the companies who are accepting deposit from members of public. This procedure is only for the companies who are not falling under the exemption category. For private company, IFSC public companies, startup companies, this procedure is not required to be followed. They just need to pass a normal ordinary resolution in the general meeting. So for the applicable companies, first they have to conduct a board meeting and pass the necessary resolution and also approve the EGM notice. If it is from a public deposit, then they need to pass a special resolution and file the MGT 14. If it is from member, the ordinary resolution will be sufficient. If you are accepting secure deposit, then you need to execute appointed, also execute agreement in form DPT2. If it is secure deposits. If it is again, you have to obtain a credit rating from approved credit agency as specified with NBFC. If you are accepting deposit from members, there is no requirement. Only from if you are accepting deposit from public, then only you need to comply with the credit rating. Then filing of Deputy 1 with ROC at least 30 days before issue of circular or advertisement. If the deposits are secure, then you need to also file the CAG1 form for charge creation on the assets of company. And post completion of 30 days from filing Deputy 1, you can issue the circular to members or advertise the circular in newspaper if you are accepting public deposits. This is only for the companies who are applicable to follow these rules, not for the exempted private and IFSC public company. This is a brief provision. Then once the company get the receipt of money or a check, then it has to issue a deposit receipt within 21 days from the receipt of money. And from it also has to make a necessary entry in the register within the 7 days from the date of receipt of money. So once you issue a receipt, you need to make the entry in the register within 7 days from the deposit receipt. This is a standard format for the maintenance of deposit register as per Rule 14. A register shall be maintained for at least 8 years. You have to maintain at a register office. And the following particular should be entered in the register, namely the general details, the depositor's name, address, PAN number, nominee, and the amount of deposit maturity period. The deposit insurance, which was there before the 2017, has been done away. So right now there is no requirement to have a deposit insurance contract with the insurance company. So this is not required to enter in the register. Now, if you are accepting secure deposits, it is compulsory to appointed deposit trustees. So rule prescribe that some category of person are not eligible to become a deposit trustee. First category is if you are a director, KMP, officer employee of the company or a group company holding subsidiary company, or you are a depositor in the company itself, then definitely your interest will get biased. You cannot accept you cannot be appointed as a trustee. Second is if you have peculiar interest, you have indebted to the company, their subsidiary company, holding company, fellow companies, then you cannot be appointed as a trustee. Third is you have entered into a guarantee arrangement regarding the securing the principal date of the deposits, or you are related to the directors or their officer employee KMPs of the company. So this all are saying that if you have some biased interest or you are not independent, then you cannot be a hold the position of deposit trustee. If for any reason the board want to remove the trustee, then there is a specific provision which says that you need to pass a unanimous resolution at the board meeting. So you cannot pass a resolution for removing trustees, and it should be passed at a board meeting with the approval of all the directors present at the meeting. And if the company have a independent director, at least one independent director's consent is also required at that meeting. So for removing the trustee, you need to pass a unanimous resolution at the board meeting only with the presence of ID if you are required to appoint them. So this is the procedural part. After this, the annual compliance, certain compliance disclosures all the companies have to made. If you're falling under the applicable companies, then you need to deposit 20% in the depository reserve account on or before 30th April. That is only for the applicable company, not for private company and IFSC public company. Annual return of Deputy 3, any company, whether is accepting deposit or exempted deposits, both it should report to the ROC by 30 June every year. Is compulsory, irrespective of accepting deposits or exempted deposits. And as discussed, if you're accepting deposit from directors or a relative of private company director, you need to disclose in financial statements also by notes in board's report also. These are the annual compliances that you should don't miss out in order to avoid penalties. Apart from annual compliance, there are some other compliance that will be automatically get triggered if you are accepting deposit exceeding certain amount. Say if you are accepting as per Rule 4 of the company's appointment collection data 2014, it states that every public company which have an aggregate outstanding loan, debenture, deposit exceeding 50 crores, then they have to appoint at least 2 independent directors on their board. And also the requirement of audit committee and analysis committee will get triggered. So if you're accepting deposit or with other borrowings which is exceeding 50 crore, then you need to comply with this audit committee, NRC committee, and indemnity requirement.
Yeah, just one point over here that it says 50 crores. So there is no cutoff for this. So important point is that whenever this triggers, the applicability starts.
Correct.
So generally we don't have, 31st of March of the previous financial year and all. So whenever this is accepted or this is going to be accepted, it is required. Now, the general question is that within how much time we have to take the steps. Now, there is no provision in Companies Act that within how much time we should take, but it should be within a reasonable time. And if we are in the month of, say, September, October, when this triggers, then this should be done at least by next 3 to 4 months, but before the 31st of March. So at least till that point of time, the compliance would be done and the reporting can be done. But there is no rule provided in the Companies Act. So typically in these situations, whenever there is a non-compliance, from which day you count the non-compliance, there is a question mark that from when do we start. But there was one compounding order, I don't remember which company. It had counted from 3 months from the end on which the provisions were triggered. So they gave 3 months for the company to comply. And after that, till the time they comply, those number of days were counted. So probably this is the only way of calculating. But for point number 1, there is no cutoff. For point number 2, there is no cutoff as such.
Gaurav sir, you said na 3 months. I think that is because if you read the section 149 is saying if any casual vacancy arise for the post of independent director, it should be filled within next 3 months or the next board meeting, which is later. That's why the calculation period is starting after 3 months, maybe.
Okay.
Probably the point here is the action should be taken as early as possible in order to avoid the penalty. That is the thing.
Correct.
Yeah.
Second compliance that will get triggered if you're accepting public deposits. There is no limit if you're accepting 1 rupee also from public. You need to consider a vigil mechanism as per Rule 7 of the company's Meetings of Board and Power Rules 2014. So this aspect should be considered in mind. Not only you need to comply with the deposit rules, also other compliance on the companies that you need to check before accepting deposits from public. Third compliance is retirement rotation by auditors. If you are accepting public deposit of 50 crore rupees or more, then your company will get covered under section 139 subsection 2 that deals with the rotation of retirement of auditors. So these are very important compliances that you should check before inviting deposits. Penal provisions, I must say, the most stricter penal provisions are for deposits and any other violation of section. Section 76A empowers the government to impose a penalty in the form of fine on the company, which can be from 1 crore rupees or twice of the deposit accepted, which is lower minimum fine, which can exceed up to 10 crore rupees. And for the officer who is in default, there is an imprisonment of a maximum of 7 years, and there is a fine of at least 25 lakh, which may extend to 2 crore rupees. Here, it should be noted that there is no such compounding that you can do because there is a criminal liability. It is not decriminalized. It is what and imprisonment and fine. So you cannot go for compounding for the officer who is in default. And if you're violating the section grossly, if it is come to the government that you are willfully or with the intention to deceive the stakeholders, you have accepted deposit, then you will be penalized under section 447, that is related to fraud. So this is our very important penal provisions. If you are not complying with the deposit, if you are taking it on a lightly basis, you will be in trouble. Your company will be in trouble. Apart from this penal compliance, this it's not end here. Also, directors will get disqualified. Section 164 says that subsection to clause D, if the company who default in repayment of deposit or any interest thereon for a continuous period of 1 year, then the directors are not eligible to be appointed or reappointed in that company, and also appointed in any other company for 5 years. So if the company defaults in the repayment of deposit or interest for continuous period of 1 year, then directors will get disqualified for 5 years from being appointed or reappointed. These are very strict penal provisions.
Either any way to make good this non-compoundable offense and get this settled.
So nothing as of now.
Nothing can be done. Only thing is you be compliant. That's all.
Yeah, settlement. We have not got the provisions in the Companies Act, just like SEBI regulations. But I think in one of the reports there was a reference of settlement provision, but not yet introduced.
It is a recommendatory, sir. It is not yet executed. Yes.
Yeah, not yet.
So these are the consequences of if a company defaults in repayment of deposit or interest. Now let's talk about remedies available to depositor. If company default in repayment, then what is the remedy to depositors? So the remedies available to depositors are, they can apply to NCLT for the compensation under section 73 subsection 4 if company makes default in repayment of deposit interest. Further, the wider remedies available under section 245 in the form of class action suit. They can also demand compensation from the negligent directors officers who are grossly deceive their depositors. Then also under section 37 also they can file a suit if there is a misstatement in the statement made or in the circular made. And the recent remedy is you can also go under the CRP process under the IBC being a financial creditor. There is a certain limit. If you fall in that limit, you are recognized as a financial creditor. You can go apply there under the IBC code also. That's the remedies available to the depositors. That's it from my end. If any question, I'm happy to answer.
So far, all the questions have been answered unless new questions comes here. What do you think? I can see there is one message has come. Gaurav, any recent case where class action suit was filed with the compensation from the director under section 245?
Yeah, actually, I'm not aware of any recent case on class action suit. I think so. Though the provisions have been notified, this has not yet triggered in India, the class action suits.
I also not come across so far.
Yeah.
I don't think there's any questions.
I think yes, we can close all questions we have answered. And I think I'll thank all the participants to spare the time, and also Gaurav for your time and solving all the questions and also giving all your expert comment. Mr. Bala, as usual, thanks for your contribution. Neel, excellent presentation and question answer session conducted. Thanks everyone. Thanks for being here. Thanks.
My appreciation to Neel, especially you have covered everything, putting A to Z. Excellently, you have done a very good job. Thanks, Gaurav, for sharing your practical experience. Definitely, we get our knowledge enriched in today's sessions. Thanks a lot to everybody. Thanks a lot to participants.
Thank you.
Thank you, sir.
There have been a couple of questions whether the PPT will be shared, etc. Yes, PPT will be shared on your registered mail ID, and you will also get the proceedings available on YouTube for your information.
Thank
Thanks
you,
a lot.
Dipti ma'am.
Thank
Thank you, Bala sir. Thanks.
Thank you very much.
Thanks, Neil.
Good day.
Thank you. Good day.
Enjoy your weekend.